Yes, Mr. Hall.
My lady, the specific question was how do I address the question of time?
Yes.
I think, if I may, I'd like to go back to look at what exactly this situation was. Mrs. Anwar complained for the first time that I can see in the bundle in May 2020. She asked for the curb to be raised, but she asked for the curb to be raised, if I can take your lordships and your ladyship to that complaint. She raised that complaint as a litigant in person,
Yes.
without the assistance of legal representative. It's at page 157.
Yeah.
And it's recorded in an email from Ealing to her.
Yes.
And the nature of the complaint was a dropped curb has been placed without any permission or consent. I submit that she can't be expected to know the specifics of section 184.
No.
That was raised and then went through the proper procedure.
I'm just not with you. Page 156?
Oh, I'm so sorry.
158, sorry. Beg your pardon. I've got
Yes,
it.
157 it starts and then 158.
Got it, yeah.
Is the material of it. I simply put the case in this way. Had the claimant, applicant, appellant and claimant gone to the administrative court without first having asked the council to raise the curb, what would the administrative court have said? But why don't you ask the council, go away and use your alternative remedy? It's not technically an alternative remedy, but in effect it is, because it is, the alternative remedy is you ask the council to raise the curb, and on what basis do you ask them to raise the curb? Because the decision was unlawful in 2015. This is the first time they've been asked to engage with that issue necessarily, because Mrs. Anwar was no part in their decision making before. But the more important point is the administrative court would be quite right to say, in those circumstances, go away and ask the council to raise it. So
Well,
the first,
absolutely right. The perfectly fair point to make, Mr. Hall, that before you launch into any sort of litigation, you try to solve the problem in an amicable way, and that's why we have pre-action protocols
Yes.
and so on. So that is a very fair point to make, entirely reasonable. But the point really is that Mrs. Anwar would have been aware that the roadworks had been done whenever it was, in 2015 or 2016, because it's blindingly obvious that there is a dropped curb. And indeed, somebody on her side of the driveway seems to be using a vehicle to get in and out over it. And therefore, the time for doing all of this and engaging with the council and the complaints process would have been in 2015 or 2016 and not 2020.
my lady, I don't have really an answer to that,
No.
other than that is the fact. So this can only be considered as a late application and perhaps as a late judicial review. But what this does address, though, is the fact that the 2021 decision maker must have treated the initial decision as lawful. I accept as a proposition of public law that is well grounded.
Yes.
But what it fails to deal with is the fact that for the first time, the council is being asked to decide whether or not its decision in 2015 was lawful, and it's being asked that properly before that decision is challenged, on the basis that, amongst other things, Mrs. Anwar had no part, and nor did Mr. Khan, the landowner, had no part in that decision making. So to that extent, I submit that it is appropriate and proper for that 2021 decision to be looked at through the prism of whether or not the 2015 decision was lawful. I accept the timing points your lordships and ladyship would have to take into account that in deciding whether to quash the decision. I submit that it would be proper to do that simply because of the overriding nature of the unlawfulness of the original decision.
Well, if it's any comfort, Mr. Hall, we're not going to decide this case on a technical knockout.
Yes.
And I say this in open court, that given that a point of wider importance has been identified,
Yes.
and permission has been granted, and we've heard argument, and we'll hear what Mr. Williams has to say in reply to that argument in due course. It would be grossly unfair to your client for us to say, well, you're out of time, that's the end of, and we're not going to do that. And I make that very clear, we're not going to do that. But you will understand, and I'm saying this really for her ears, but you will understand as counsel why this court is concerned,
Of course.
about matters of procedural rigour, and we want to sort of explore with you the timing issue, because it's all part of the background picture. So I'm just saying that by way of reassurance, because I don't want your client to go away feeling that she's not having her arguments properly dealt with. They are going to be dealt with. We are going to hear from Mr. Williams about them. All right?
I'm most grateful to your ladyship for that. I want to just, if very briefly, touch upon the situation if the 2015 decision was lawful. The appellant still appeals on the alternative basis against that or other. And I deal with that very, very simply by saying that accepting, of course, that the chief executive's decision must be considered through the proper conventional public law principles, accepting that all considerations need to be, relevant considerations need to be addressed in that decision, not irrelevant decisions in all relevant decisions, accepting that you would then look through it through the prism of a lawful decision having been made on a proper interpretation of the law.
Yes.
I submit that there are circumstances where manifestly inadequate weight can be given to relevant considerations, or manifestly inadequate weight to relevant considerations. And that this is one of those, given the importance of the lack of consultation. And on that basis, I ask you still to quash the decision even in those circumstances.
So, manifestly inadequate weight can be given to relevant considerations.
Yes. I can give, it's not in the bundle.
No, don't worry.
I can give your ladyship citation on that.
Yeah, so you say it was a relevant consideration that there were grounds for challenge even if they hadn't been pursued.
Yes.
Is that the way you put
it?
it?
So what I'm saying is that on any view I submit, it would be preferable to consult neighbouring properties, even if that isn't a legal requirement.
Yes.
Indeed, the council accepts that. And that in circumstances where that hasn't happened,
yes.
That is such an important a sufficiently important decision that, in this case, should or could have led the decision maker properly directed to accept the application to raise the curb.
But how do you get round the objections that were given by the council ultimately to that option? Because they certainly considered it as a possibility, but they came up with the point that the tree roots, etc., and the moving of the standard lamp, I mean, why isn't that a complete answer?
Because the proper approach to that, in my submission, would be to say, well, it's unfortunate that property A that has the tree root access problem can't therefore have a crossing unless it is shared with another property. But that is the situation, and that unless the other property agrees to it, that means that there will not be able to be an accessible vehicle crossing. Not
so
every
you're
property.
effectively saying there's an option 3, because option 1 was to try and move it, as my lord put it, 6 inches to the left, or a little bit more than that to the left. Option 2 was the bollard.
Yes.
I'm going to ask you about the bollard in a minute. Option 3 is to reinstate the highway in exactly the way in which it was beforehand. Who's going to pay for that?
Well, I don't think there is a statutory procedure for that. The council might have asked Mrs. Anwar to pay, I suppose. I don't think they could have asked. Certainly
they'd received money from the next door neighbour, had they not, for constructing the crossover in the first place.
They have. There's nothing in section 184 to allow the council to to require any owner or occupier to pay for raising a curb.
No.
But I submit they would have the power to say, well, if this is your application, then we'll do it, but you have to pay for it. And obviously they would also, in fairness, need to consult the neighbour. But there would have to be a public law process, a fair process, to ask them to do that.
So you'd be back to the situation where there was the curb reinstated,
Yes.
which didn't prevent access being gained.
Well, it probably would.
Because we've seen photographs in the bundle of cars in front of both properties in 2015.
Yes, we have. But my understanding is that the council's case is that there had to be sufficient. So I'm looking at it again, page 44. It wouldn't be sufficient to allow. So maybe the neighbour's car in that photograph is.
So you're on page
44.
I think that's a more recent picture, though, isn't it? That's the one with the drop curb.
It's the one with the dropped curb, indeed.
Could we look at page 163? It's
Yes.
unfortunate. I know it's judicial review, but you still have to have facts and evidence. I'm
Yes.
like a crack record on this, I know.
Yes.
But I've got a picture of 163. I've got no idea where it comes from, who took it, whether it was in a witness statement. But that's a much more helpful one because it's closer. And I assume the red line
Yes.
and the water is in effect the division and
Indeed.
boundaries.
Yeah.
And it would be really useful to know what that is and what the dimensions are, because going back to the Article 1, even I might be able to drive
You can't
into
do
the
it.
left-hand property at a push.
The-
Or do we know anything about this photograph at all?
reason-
Is there any evidence about dimensions?
Yes, there's dimensions in his lordship's judgment, I think.
Oh, good.
This is why I didn't think I'd. So the facts.
I mean,
we
that
have-
photograph has been taken really from the edge of the carriageway, hasn't it?
Yeah.
Yes.
Looks at it.
That's right. On the other side, really.
Well, depending on how it's been cut and blown up since.
Oh, depending on which photograph. Sorry, photograph at 161.
161.
Yeah, 16. Yes.
163 I was looking
So
at.
that presumably shows the dropped curb. It doesn't show the curbstones. So it must have been taken from close to the edge of where the cars would be parked on the other side.
So where are the dimensions in the judgment?
I do recall seeing dimensions somewhere. Maybe I'm misremembering that. Yes, yes. Oh, maybe it's only dimensions on the basis of standard.
Well,
costs.
there is the photograph you took us to at the beginning this morning at page 44.
Yes, that's that. Yes.
2.7 metres, and you can
Yes.
see that related to the width of the car.
That's the.
And that's when I asked you questions about the shared drive and how both owners, in practical terms, are probably using land of their neighbour when they go in and out.
Which I think I accepted.
Probably
Yeah.
because of the turning circle.
Yeah.
Yeah.
Because although physically, if you look at 163, you might be able to drive straight in on the left-hand side. If you're going to park the car on the paved bit in front of the house, you probably need to turn, and it may be too tight a turning circle. I'm not sure.
Yes, it may be.
There shouldn't really be speculation about this. There should
No.
You know, even in a judicial review, it's quite easy to measure. So I don't understand why. I haven't gone back to the claim form since last week, whether the claim form says this, but you must make proper claims with proper facts and proper evidence. Anyway, you haven't got any more than you've shown us, you say.
Well, no, I have the letter, which may include. So obviously the decision, the 2021 decision 151. And so it certainly it refers to the reasons for the curb being lowered at that point at 152 option 1, because it says current crossovers policy minimum front garden depth of 4.2 metres. And then it says the exception is a 4.2 metre depth is where the property frontage width is a minimum of 6.65 metres, which is the case for one property, but it would require entry and exit at the current crossover position. So that's why I didn't submit. Obviously, I wasn't involved in this case until April anyway.
Yeah.
But I didn't think it was necessary to draw the court's attention to facts, simply because it seems to be an agreed position that if for an effective crossing, whether it's 2 or 1 technically in law, putting that to one side, for an effective crossing, it would need to encroach on to...
Well, the problem that I have with that then, because that's what I thought you would say, but then I read the next one under option 2, placing a bollard at the edge of the footway to prevent driving onto any part of your property whilst retaining access
So
when you go to the other property. So it looks from the next part of the letter as it would be possible. Do you follow me?
It does, but my lady was about to ask me that question, or I'll deal with it now. It sits uncomfortably with the council's decision that they needed to encroach, to drop the curb adjoining the appellant's property.
Could we look at what the judge said about this?
Yes.
In 2 paragraphs, 13 and then 74.
Yeah.
In 13, and no one has said he's wrong about this,
Yes.
both properties are able to use the crossover. And a white car is parked outside the appellant's home.
Yeah.
If she wished to get to that spot with a vehicle, she would have to use the crossover.
She would. And
go across Mr. Johal's land as well. This is inevitable.
I agree.
And then if we go to 74, that's the reference I had in mind. Page 69, line 3, Mr. Wilmshouse, who was then her counsel, pointed out there are photographs in 2014, 2015, showing vehicles parked past the curb. There is a white car on the forecourt, etc., etc. I didn't.
When your lordship raised that point, I accepted it immediately.
Yeah.
Well,
not surprisingly, given the judgment.
Well, given the judgment, also given the photograph, but the fact that it has been used has no bearing in my submission on the legal question.
That's a different point.
Because at 163, it's harder to get into the right-hand property through that narrow thing with the fence, and I haven't got the measurements. It looked, I definitely couldn't get into the right-hand side. On a good day, with a bit of concentration,
you might get into the other one.
We shouldn't be speculating on this.
But
if your claim
the reason I didn't think the court needed to have any further facts, and in any event, I couldn't do anything about it at that stage, when I had to apply even to have a substituted skeleton argument, understandably, but I did. The reason I didn't address it is because the judgment makes it clear. In fact, the decision makes it clear that it was thought by the council the necessary to have a sufficiently wide access point to encroach upon the other property, if that's the right word, but obviously one can use more neutral and legally correct term. Drop the curb adjacent to a neighbouring property. And on that basis, measurement wasn't needed, and nor did his lordship think.
I take it that the bollard is not in place at the moment.
No, the bollard's not in place, but the interesting thing about the point is the bollard is if the bollard could be done, then why the need to have such a wide access point? It seems inconsistent with the council.
We don't know. That was what the council did in 2015. You haven't got any evidence about it, or we can't speculate as the court.
I'm not asking
why
the court
they
to do
did
that.
that length at that time.
I'm not asking the court to do that. I'm only saying that in 2021 the option of a bollard was placed. That sits uneasily with the council's decision, earlier decision. I accept.
We just don't know.
Why?
As I understand, we can go back to the letter if necessary. Option 2 stated that the bollard could be put in place so as to prevent access by anyone to number 65 via the crossover.
Yes.
That's consistent with the judgment.
Yes. It's not consistent with the need for a wide crossing because it would inevitably restrict the ability of the car in the neighbouring property to drive in, and then
Well, that we don't have evidence about. What we do have is
Of
what
course.
the council said.
We don't have evidence about that. We have evidence that was an option that was canvassed and not taken up, and that's probably all I can say about that.
Yeah.
But do we know anything at all about why it wasn't taken up? Because it would be a bollard on your client's property, and that actually would be
No evidence.
something that required the claimant to consent.
No evidence.
No evidence.
Other than that she refused that option.
She refused it, did she?
Yes.
And we know that because...
Well, I can take instructions.
Because it hasn't happened.
Hasn't happened is the answer. Yes. I can only presume that it would have happened.
Well, I think we can take judicial notice of the fact that because she's challenging the decision which offered that as the option,
Yes.
that she doesn't like the idea of the bollard.
Yes.
And I can well see why she wouldn't like the option of the bollard, because it would mean she wouldn't be able to get a vehicle into her own driveway.
Yes.
We don't know anything at all whether it's her or the freehold owner, because it may be that Mrs. Anwar can't drive or doesn't drive. And the letter refers to the leaseholder. It's rather unfortunate we've got none of these facts. But we just don't have any evidence to be whether it's the leaseholder, the freehold owner or the current occupant, do we?
Well, I'm given some instructions, but I don't have any evidence that I can point to illustrate those instructions. So I'm not sure how far that's going to take me. In terms of, not in relation to the bollards, in relation to a different point about whose the parked car was outside the appellant's property. But in any event, I submit that the bollard point is of no relevance to the central point of statutory construction.
All right.
On the, as a tidying up exercise, it
Yes.
probably doesn't have an effect on the legal issues, but title is dealt with at tab 38.
Yes.
And we have extracts from the land registry certificates, but if you go to page 220, we have an extract from the freehold title
For the property owned by Mrs. occupied by Mrs. Anwar.
Exactly, and then, but if you go over the page, there is a leasehold title, different title number.
Yes.
And under propriety rate, it's a 99-year lease, as you can see from item
Yes.
section A, and then the proprietors are set out,
Yes, I see.
and it includes apparently Mrs. Anwar as a joint owner. This is a 2020 extract,
Under a
admitted.
99-year lease.
Can I just?
Sorry, 99-year lease.
It may not matter, but just
Which page are we looking at?
page 221.
May I seek instructions on that?
Oh, yes.
Yes. So
That's
I
about
don't
the
know
time
why
of the
this
complaint.
seems that the your lordships can clarify a situation by reference to this and confirm in your lordship's judgment that, and your ladyship's judgment that, it's she is a long leasehold.
She is a long leaseholder.
Yes.
Under this title.
She is the lady referred to.
Not just an occupier.
No, indeed.
Right. Okay.
So an owner, I submit that must meet the definition of owner.
Yes,
Yes.
Don't think there's any.
definitely.
Yeah.
It's a long lease.
Yeah.
And I had, on this particular ground, if you wouldn't mind going back to your skeleton, page 34 of the core bundle,
Yes.
paragraph 44, you deal with the alternative submission, what if the 2015 decision was lawful? But the first submission that's made there is that the respondent misapplied the crossover policy in its 2006 document in relation to trees and streetlights and so on. I mean, I don't think this has been developed anywhere.
It was developed.
Is it, can we take it it's not something you're pursuing?
Yes.
Thank you. And likewise 45 and
I think the
and
only
then 46
point, I think the only,
comes to the bollard.
on retrospect, the only point I make about that is in that manifestly inadequate consideration to relevant consideration. I don't think I can take it any further.
Okay.
And then do you rely on 46? Sorry.
I'm so sorry.
Do you rely on paragraph 46?
Well, I inherited that ground, my lord.
Yes, that's why I'm asking whether you
I
rely on
don't
it.
have instructions on not relying on it, but I haven't pursued it. Your lordships may wish to make a decision on it. I can
You
take
haven't
instructions now if you wish.
Good.
I think, my lord, the situation is a little bit difficult with a client who doesn't speak very good
Okay,
English.
don't worry
I
about that.
would
So
rather
you
your lordships dealt with it.
maintain paragraph 46.
I do.
And the only one you withdraw is paragraph
Thank you.
44.
Indeed.
And 45.
Yeah.
No, you maintain 45, don't you? You argue that 45 is
Well, we're not having an argument on policy grounds, are we? We haven't been shown the policy.
I accept you haven't been shown the policy, and therefore I can't develop those arguments. I think
No,
it's
but the last
right,
sentence,
The last
you rely on that, don't you?
Yeah.
Yeah, manifestly inadequate weight is
think that's what
absolutely.
Mr.
Well, to that relevant consideration.
Yeah,
Oh,
to that
yes,
relevant
yes.
consideration.
That's all wrong then.
May I assist your lordships in relationship any further?
No, you've been extremely patient, Mr. Hoare.
No, not at all.
I should say for the again for the benefit of Mrs. Anwar, you may feel that we've been asking an awful lot of questions of your counsel. It's the normal way that these things operate in the Court of Appeal. It doesn't mean that we have made our minds up anyway, one way or the other. It is just that we have done our homework, we've read everything, and we always invite counsel to help us with matters that we feel we need some help with, and just to understand their case and to make sure that we understand how the case is being put on your behalf. All right, so please don't think we're being nasty to Mr. Hoare or unfair to him by asking him a lot of questions. He's a very experienced counsel and he knows what he's doing. All right?
I have pretty broad shoulders, my lady. Thank you.
Gathered that, Mr. Hoare. Thank you very much indeed. Mr. Williams.
Thank you, lady, my lords. My overall submission, as the court's aware, is that the judge was correct
Yeah.
for the reasons he gave. In relation to grounds 1 and 2, it's now common ground, it wasn't in the court below, that this is simply a case of a request made under subsection 11.
Yeah.
And so the only issue before the court is on grounds 1 and 2, is the interpretation of subsection 11.
Yeah.
And I submit that it's necessary, applying the ordinary principles of statutory interpretation, to focus on the words used in that subsection, reading them in context, of course, and having regard to the statutory purpose. And I don't propose to take the court to established principles of statutory interpretation, but recently the For Women Scotland Limited case, which is at tab 14 of the bundle, page 314, paragraphs 9 and 11, emphasised the focus on the words that Parliament used as the expression of parliamentary intent.
Now, I think that possibly one of the main points against you, as far as I can discern it, in relation to the statutory interpretation, is that when one is considering the purposive construction of the statute, and in particular the fact that the crossover is designed to stop people driving over the curb and causing damage to the highway in a particular location, the people who are likely to be doing that or affected by it will be the owners or occupiers of fronting properties. And the word any person or any can at least be interpreted as meaning any interested person or any relevant person in context. And I think what is being said is that the only people who have an axe to grind, if I can use the vernacular, are frontagers. And that would include a neighbour who is likely to be affected by it. So that's one of the arguments anyway. I'm perhaps putting it slightly differently from the way Mr. Hall's putting it.
Lady, I understand it. And as I understand it, though, the way that that submission is borne out is to say that any person in this legislation must be given a specific meaning.
Yes.
As meaning any person occupying or having access from an adjoining individual set of premises may apply.
Yeah.
And in my submission, that's such a large departure from the ordinary meaning of the words that that's inappropriate as a construction of the language used. And in my submission, many of the contextual points my learned friend relies upon by reference to the language of subsections 1 and subsection 3, which do use words such as premises, adjoining land, go against him, because where Parliament intended such limitations to be in place or such language to be used, it did so. And the purposive point is dealt with really by the fact that the only works that may be undertaken as a result of a request are in the highway land, in the highway verge and the highway footway, and the request triggers, broad request, triggers the exercise of statutory discretion by the highway authority, who may reflect on the specific crossover proposed in the application, and they may accept it, they may require it to be modified, they may propose an alternative, or they may reject it. And that discretion has to be exercised pursuant to the statutory purposes of the highway authority, and given that it's only affecting land in highways ownership, and it's only lowering a curb to facilitate access, Parliament felt that no additional safeguard was required, and that's entirely consistent with the statutory language, which confers a broad trigger, if I may use that.
One more modest way of putting the claimant's case could be this. If you look at 1841, true it is that it doesn't say that a vehicle crossing is between the adjoining premises and the highway, but that's what triggers a section 1841 activity. It's implicit in the schedule. You can complain that somebody else in the premises should pay, but it doesn't contemplate that somebody at another premises will benefit. You could try and say it's implicit in that. Then when you get to 18411, that's just a follow-on. If they're not forcing somebody in adjoining premises to pay for the cost of a crossover, but they would like one, then 18411 is providing for that. So when it talks about any person, we shouldn't focus on the words any person. We should look at vehicle crossing. And when you look at vehicle crossing, true it is, the words don't say between the applicant's adjoining premises and the highway, but it's really following on, Mr. Hoare might say, from 1841, that this is just another way in which you can link the highway to the premises wanting the link.
Well, my lord, in my submission, no linkage is appropriate in that way for two principal reasons. One, that which I've given, which is it uses entirely different language. And two, which is that one can see subsections 1 through to 10 as an involved statutory code that deal with two fundamental situations. The first being subsection 1, which is where an occupier is habitually using the verge or footway, pursuant to a right to do so. That's one trigger. The other trigger is where planning permission has been granted for development of land that has access to the highway, either because it's adjoining or because it has access to the carriageway, that's going to make it, in the highway authority view, necessary to construct a crossover.
And that subsection 3 applies where the land is being or is to be developed. Not where it has already been developed pursuant to the permission.
My lord, yes, that's right. This is anticipating that it is the planning permission, so it's not the status quo of an existing user using the verge habitually, but it is where permission has been granted and that permission is to be or is being developed. Obviously, it may be being developed without yet getting...
Going back to the first scenario where the habitual user provision, we haven't looked at subsection 2, but that excludes the use of subsection 1 to construct a vehicle crossing where a vehicle crossing is already made up.
Exactly. And if you...
Whether under this provision or its antecedent, section 40 of the 1971 Act, or any earlier.
So in effect, the authority can't use subsection 1 to improve an access that has already been, or a crossover that's already been made up.
But it goes a little bit further than that, because under subsection 1 what they can do is to physically create the crossover, or they, under subparagraph B, impose conditions on usage. But this excludes the imposition of conditions on usage under subsection 1 of this provision, where the crossover already exists. So, as I understand what you're submitting to us, the first two parts of section 184 are highly specific, dedicated provisions.
Highly specific, dedicated provisions which arise because there is a right of access to the carriageway.
Yes.
And where the highway authority initiates a procedure because its view is that those works to cross the verge or footway should be undertaken. In order to form the view as to whether or not those works should be undertaken and what works they should be, the authority has to have regard to subsection 5. Subsection 5 is slightly complex in that it's in two parts, in that the first 3 words relate to in determining whether to exercise powers. The second part after the comma is more specific as to specific considerations to take account in determining the works to be specified in the notice. So those matters have to be taken into account by the authority, firstly in deciding to initiate the process, secondly to decide what specific works, what crossover should be provided. Having done that, the highway authority has to serve notice. The notice has to be served on the owner and occupier, and we know that from subsection 1 and subsection 3. At the same time as serving the notice, the combined combination of subsections 7 and 8 is that they have to inform the owner and occupier of the effect of the provision, that they intend to or will have the power to execute the works, and that they will be able to recover the money. All that has to be done as part of the initiation of the process under either subsection 1 or 3, and that then, through subsection 6, gives rise to the right to objection on the specific grounds that the court reviewed in Schedule 14.
Do you say that the right to object on Schedule 14 grounds is exhaustive, or would you say that there are other grounds that could be raised?
I would say, my lady, it's exhaustive when one looks at the language. This is at page 19 of the authorities bundle. It's a fixed time limit, and the person may object on any of the following grounds which are appropriate in the circumstances of the particular case. So one would raise an objection either on one or more of these grounds. And when one surveys the grounds, for example, first one, this just isn't a 1841 or 3 case, so you shouldn't be acting at all. Secondly, you haven't followed the proper process. Thirdly, the proposed works are unreasonable in character or extent or are unnecessary. And
I think Mr. Hall places particular emphasis on the word extent.
Yes,
in
but
that regard.
it's, in my submission, important that somebody does have the power to object on grounds of extent, because they're going to be paying potentially for the works, and it might not just be width, although I accept extent falls within width. It might be that it's just far too complicated and unnecessary a process.
Well, you get an example of that because this provision applies to subsection 3, and under subsection 4, the development case, the highway authority can say in its notice that you need additional acceleration and deceleration lanes. You might get an over-designed junction.
My lord, exactly so. And I was going to refer to that also because my learned friend in his skeleton at paragraph 24 plays down the role of the cost of some of these works. But this is a section of broad application, as my lord highlights. It may be providing crossover works for a new residential development.
Yeah.
It may involve significant incursions into the verge.
Well, in fact, just thinking about this, because my lady was drawing attention to the statutory history, what we see in Schedule 14, I think, was introduced in the 1971 Act. I think it was, I had a brief look at lunchtime, I think it was Schedule 3. And what the 1971 Act did was to insert a replacement for Section 155 of the 1959 Act. In the 1959 Act, subject to correction, any person, or rather an aggrieved person, could appeal to the magistrate's court. There wasn't an objection procedure which went to the minister. Instead, you could appeal, if you were aggrieved, to the magistrate's court. And the statute didn't say what the grounds were. So what Parliament seems to have done in 1971 is introduce what we now have as Schedule 14, saying you can object, it goes to the minister, the notice has no effect until the minister has dealt with the matter, and these are the grounds, as appropriate. So it's a code has been introduced.
And
it was at this stage also in the 1971 Act, as I understand it, when the planning, if I call it that for short, the planning example in subsection 3 was introduced. So one could see why they needed to spell things out a bit more, given that widening.
And my lord, as you know, my submission is that when one reads 1980 Act on its face, one can discern. I totally accept the history of the legislation may well be.
Well, it might make it even clearer.
Helpful, which is why
when you compare what it was like in its cruder form in the 1959.
And also see why Parliament would want it to be dealt with by a much more streamlined procedure than leaving it to the local magistrates' court to deal with, as it might have done, when in the old days of the Parish Highway Authority.
I mean, Lily, just coming back to your question about extent, the reason I was going down those answers.
Extent means magnitude as well as width.
And another example of that is given in subsection 50, where it's noted that the expenses recoverable may include the costs of effectively relocating the apparatus of statutory.
Could we just look at subsection 7, because it says where a notice under subsection 1A or 3 has become effective, then the highway authority can execute the work. So the implication is they can't do so beforehand.
Yes.
And my understanding is if you go to Schedule 14, somewhere I think I read that the notice isn't effective whilst the objection is outstanding.
Well, it's over the page. It's 5. It's rather odd.
Thank you.
Such a notice becomes effective
Yes, thank you.
at the expiration of the period during which the person served therewith may object to it, which is the 28 days.
Yeah, yes,
But what happens after 28 days when the minister is cogitating over it?
One might think that perhaps...
Oh, that's little 4, actually. That's all.
I think
the notice does not become effective until it's been confirmed. So you've got 28 days. It's not effective. If there is an objection, then until the minister determines it, the notice is not effective.
But
Lord, yes,
as a coherent code, one might think that the only basis upon which a highway authority can be prevented from going ahead with its works and then charging them is if there is an objection which is properly within the scope of Schedule 14.
Lord, I see the force of that.
As opposed to anything in general.
Yes. Well,
Like a planning point.
One of the specific grounds is consistent with, as you say, my lord, that 1A, that the notice is not justified by the terms of section 184, 1A or 3. My reading of the legislation is that in the event that the notice is properly served, and if there is no objection, it will become effective after 28 days. Yes. In the event that there's an objection which is maintained, then it won't become effective until there's a ruling by the minister which may modify it or indeed not uphold it.
Yes, you're right to put it that way, but on the other hand, the further extension of time, as it were,
yes,
impeding the local authority's use of its powers wouldn't apply to something which didn't properly fall within Schedule 14.
No,
you can't put any objection in. It's got to be something referable to the schedule.
And just to return to the other grounds momentarily, there's potential to object on the conditions being unreasonable. Part E, which was discussed earlier, that some other person having an interest in the premises also habitually takes or permits to be taken a mechanically propelled vehicle across the footway or version should be required to defray part of the expenses.
So would that cover the situation that my lord came up with of the Victorian house that has 2 flats in it? They served the notice on the owner of the premises, let's say the freehold owner, and the 2 occupiers, but the owner says, well, hang on, it's not just me using my vehicle, it's 2 other people who are living in my property.
My lady, yes, the trigger, has in mind obviously a subsection 1 case E. And so the trigger is that there is an occupier that is habitually
doing it, yeah.
Doing it. And the requirement, and this again reflects in my submission that this is about properties that already have, or people who already have a right to access. The notice is served on the owner and the occupier of the premises. There may be more than one owner, and it may be that if a notice is served on one person, they're given the right to say, I'm not the only person doing this, and that all.
The obvious about that, and that's why I was asking the helpful question to Mr. Hoare, is that contemplates that somebody in the premises, the adjoining premises, that have triggered the notice in the first place, can be asked. It would be the top flat and the bottom flat. But if they've decided to do works which extend to somebody else's property, and they also get the benefit, they can't under E say, there's some other premises, the ones next door, they benefit too, why don't they pay a contribution towards it? And Mr. Hoare, I'm sure, would want to say, that's because the whole of this process in 84.1 is dedicated to the adjoining premises and a crossover to that adjoining premises, and the people who are beneficiaries being the people in that premises. And then he wants to extend it to subsection 11, if you follow me.
I do follow, and you know my submission on the latter point, certainly about the appropriateness of extending it, even if that were right. But in my submission, it's not right, in that this is simply a provision. Firstly, it recognises that there may be more than one person interested in the premises, which suggests that the premises, as my Lord Justice Holgate indicated earlier, might be an industrial estate. Yeah. It might involve a number of buildings with one access. It might involve a number of tenancies, licenses, freeholds. And the provision is providing a broad, in this case, answer to say I shouldn't have to pay for all of this because I'm not the only one using it. In my submission, this tells you nothing about whether or not it's serving an individual interest in land or an individual, what we might view as a building or plot.
And presumably, if somebody next door is getting a benefit, you could say under 1C, you don't need to go so far up the street. Stop further, it'll cost less, and I can still get in. And if in fact it has to go further up to let them in, then they should pay, I suppose you would say.
And my lord, in this situation, in terms of the highway authority's actions in proposing a crossover, it need not distinguish between next door, if I may put it that way, in that what it's proposing
works on the highway.
is just the crossover in the highway, motivated by the fact that someone's driving over the Virgil Highway and this is the situation that needs to be dealt with. You're then into the exercise of discretion. What's the best way to deal with it, having regard to the need to protect the highway and safety of users. You put forward a proposal. The person you serve it on, saying we're going to charge you for this in due course, might say, well, either someone else is using it, I should only pay half because it serves more than one property, or they might say you've gone too far, this is going to give benefits to other people, and if you're charging me, it ought to be constrained to a lesser, it shouldn't be sufficient to carry 10 houses or 20 houses worth of vehicular traffic, it ought to be constrained to 5 because that's consistent with my use. So in my submission, all of the grounds of objection...
Just taking up that last example, if you're going to say that the cost should be shared by others as well who are using the premises, you have, under the statute, 28 days within which to raise the point. Failing, and if you don't, and no one else does, and the notice becomes effective, the local authority can execute the works and then recover the costs. And it would then be too late to say this should be shared more widely because one needs a certain relatively simple procedure for sorting out these issues.
And
that's why I think somewhere we're told, I think the notice does have to specify the ground that you can object.
Yes, subsection 8 makes clear that a notice must inform the recipient of the effect of subsection 7 and subsection 7...
And of the right to object.
Yeah. And of the right to object.
Yeah.
Except in the case of a notice under subsection 1b, when you don't have to state the effect of subsection 7 because there won't be any recovery of costs.
Yes, that's the conditions.
Yes, exactly.
Provision.
So if an authority acts to impose conditions, it can't recover any costs, perhaps for obvious reasons. If it undertakes works, it recovers the cost of the works. And not only must that notice indicate the right to object, but the notice must be served on the owner and the occupier, and those are the persons from whom the costs may be recovered.
And there's a symmetry between the two. If there's a 1841 notice and there's damage to the pavement, they may, for example, because of the presence of a tree or a lamp, have to put it further up, and it may be in front of another house. But the person who's using it and damaging the pavement will have to pay for all of it. Equally well, if somebody, as they wanted a crossover for the left-hand property here, they would have had to pay money for the crossover, even though it went a bit further up the street because of the street lamp and the street. And that does mean that their neighbours, whom they may or they may not like, might also be able to use it, because once it's on the highway, it's on the highway. And they've got to pay the lot and they've just got to swallow it, or they don't get the crossover. So you say,
well, yes, they
fair justice, really. You want the pavement lowered, you pay, mate.
pay for it and the consequences.
And the consequence, and if somebody else gets benefits, or if it's got to go a bit further up the street, you've got to pay for it if you've been damaging it or if you want it.
And if you don't like the quote,
Then you
I'm
don't
going to
do
come
it.
to this later, but yes, if you don't like the quote, if you don't like the fact that we're saying you need a particular width or complexity of design, or you need to move
Then you just don't quote.
the telecoms that's underneath your current pavement, then you don't have to take it up. You get the offer of a footway, but unless you pay the money, you don't have
But the point is, you may have to spend money to get a foot crossing way that extends further than your own pavement and which may confer a benefit upon somebody else.
But
We're assuming that the presence of a curb is a disbenefit, and it may be a benefit.
And all of the costs can only then be paid by the applicant under the statute. Of course, if they, outside of the terms of the statute, come to some arrangement, that's entirely up to them. The only other point I think to highlight in relation to the scope of the grounds is section 184, schedule 14(1)(g), where it may well be, this is the development scenario, it may well be that 1843 provides the developer with a means of getting the works done that he or she wants to have done for their development, and they will undertake to do them themselves and so keep control of any cost expenditure. And that is then, that takes one back, and this again goes to the sufficiency of control of the highway authority in that scenario under subsection 9 on page 4 of the authorities bundle. That person is then acting on behalf of the highway authority and so has power to carry out the works in the verge, which they otherwise would not have. And subsection 10, if they don't do it well enough or they don't do it at all, then default to the highway authority stepping back in and completing the work. So that's my submission, that subsections 1 to 10 comprehensively represent a code that deals with those two specific scenarios. Then one moves to subsection 11, and the court will perhaps, I'm sure, have noted that within section 329, the definitions include the word adjoining, the word owner, the word premises. So those are expressly defined terms that are used in subsections 1 and 3 and which aren't used in subsection 11. And by contrast to that comprehensive and coded scheme, subsection 11 says any person may request. It is deliberately, in my submissions, broad language. And as Lord Justice Lewis just indicated, the consequence of this isn't necessarily that there's a footway constructed or a crossing over the footway constructed. All that this broad trigger does is enable the highway authority to execute discretion as to whether or not a proposed footway should be accepted. And so the applicant needs to put forward a specific crossing proposal, subsection 11, line 2, such works as are specified in the request. So the person making the request has to specify what the works proposed are, and the authority must then exercise its discretion with those 4 options, one of which is to refuse.
But the other thing is they may approve the request with or without modification, or they may propose alternative work. So they may say, no, we're not putting it where you want it, but there's a tree and a lamp in the way. We're putting it further up the road, and then it may well benefit another property. And then the argument or the choice for the person who applied is, well, do I want it that badly? I'm prepared to pay for it, even though somebody else is going to get the benefit.
Lord, and in my submission, that is all consistent with the discretion being conferred on the highway authority to provide for what are the appropriate works in the circumstances of the case. And as my Lord Justice Holgate indicated earlier, it may well be that, if I can call it a joint crossover, or one crossover that will enable the service of a number of properties, is actually far more advantageous in highway terms because it allows for more on-street parking to be retained, or it provides for fewer individual access points for cars to enter the highway.
Or sight lines.
Or sightline.
For example, there's reference to safe access to and egress.
Exactly. So, and the example, there's a danger in giving examples that one always gives one that particularly suits one's case. But the way that I envisaged a clear example is a mews type property where you might have individual houses, but one central access lane with one point of access to the carriageway. And in that situation, you would have potentially one applicant, one person applying for the curb to be dropped. Maybe the others didn't require it.
One sees that quite a lot with new build developments, that you might get 4 or 5 houses on a larger plot of land being squeezed in, but there is only one means of access and egress from the new cul-de-sac. It's effectively been built off the road, so you've just got the one in and one out.
Yeah, exactly. So, and the effect of my learned friend submission is not that in that situation the applicant, or on receipt of the application, the authority should consult with the other owners or occupiers of the mews. As I understand my learned friend submission, it is unless that application is made as either 10
Like
applications for an individual crossover,
It can't be considered at all.
it can't be permitted at all.
But if you even look at the words, I mean, there's nothing in 11 which says a vehicle crossover is from the premises of the person requesting and the highway. It's such works in the request for constructing a vehicle crossing over footway or verge in the highway. So you'd have to start implying, well, he can only ask for things to service his property. But given may propose alternative works, that's also open-ended. And I suppose Mr. Hall would have to imply, or may propose alternative works, brackets, within the area of the highway adjoining the property owned by the requester as well. You'd have to qualify all the things that can happen under there, if Mr. Hoare is right, to make sure that the only thing that can ever happen, that the outer limits of any request must be coterminous with the premises owned or occupied by the person making the request.
I just don't see how that construction works in the Mews House example that we were discussing, because suppose you've got one way in to the plot of land and you've got 5 new houses all in a circle, and the owner of the house on the left-hand side makes an application under 11. It said, well, everybody's got to make separate applications or share the costs. Otherwise, you can't lawfully grant the application. But you can only grant the application, as I understand it, insofar as it serves that person's property. But if that is read restrictively as meaning it only serves that person's property, you could never have an application in that scenario at all, because it doesn't just serve his property, it serves everybody's property.
It becomes a veto.
Yes.
And my lady, in terms of the purpose, my learned friend makes reference as to the purpose. The purpose of subsection 11, and in my submission you should look to the statutory language primarily for the purpose in the absence of some clearly stated alternative purpose, because we're looking at parliamentary intent in these exercises. The purpose here is to facilitate crossovers in the footway or verge under a statutory power, subject to those particular works being appropriate in highways terms. That's why the Highway Authority has its discretion, and quite a broad discretion, to accept, modify, propose alternative or reject. And it enables where someone or any person makes such an application, and it's an appropriate one because it's approved or approved as modified, then they should pay for it rather than there being any alternative drain on public funds. It's a matter that's provided at the applicant's specific request, and of course if having got the quote they don't like it, then they don't have to proceed. But in terms of any suggestions of absurdity, in my submission, there's no scope for any absurdity when one realises that all that's being authorised is work in the highway's land to provide for a crossing across that verge or footway, and the only works that are going to be undertaken are going to be undertaken as approved by and as executed by the highway authority.
You could almost turn the argument around the issues as presented in this case. Sometimes the appellant is saying that for the purposes of subsection 11, the appellant's consent was required as the antithesis of objection, and that's linked to the objection procedure in subsections 1 and 3, particularly subsection 1. But in terms of subsection 11, the objection procedure isn't brought in by Parliament at all, the particular grounds in Schedule 14. And someone who says, I don't want to consent, I'm not going to join in the request, doesn't have to give any reason at all.
No.
That's your veto point. But the corollary of all this as well is that if the local authority, highway authority, thinks it's a good idea that there be a dropped curve, a crossover, it can act under subsection 1. But then the outcome is that all the owners and occupiers who benefit from the crossover will be liable to pay the local authority's costs. Whereas under subsection 11, only those who make the request, whether the others want to join in or not.
Yes, exactly so. And I think the judge recognises in his judgment that one may want to club together, but all you're paying for is the works in the highway. And a number of my learned friend submissions, the reference to Field Common, for example, make the assumption that this necessarily leads to something beyond the highway, but that's incorrect.
I think there are two separate arguments in here, each of which you say is fallacious. Firstly, that the person should have the right to object to something outside their house. There's lots of things outside their house, but this is the highway. They can't insist on public property not having or having something, say, within the confines of the Act. And the other is the trespass. But this doesn't encroach on their property, and insofar as they wish to stop somebody trespassing on their land, they have their legal rights to do so.
And my lord, I would add a third, that insofar as there may be concern about works in the highway, Parliament's entrusted the approval of those works to the highway authority. If one is proposing something if the applicant's proposing something that's over the top or might have certainly adverse highway consequences, then it won't be, or it shouldn't be approved. It should be the subject of a modification. And so in that way, questions as to the scope of the works, their extent and their reasonableness, are entrusted directly to the highway authority. And there's no need for the statutory safeguards that are in Schedule 14, because this is a voluntary application, it's not a compulsion, it's not initiated by the highway authority, and it will only ever be the case that the applicant's paying and there's no power to recover from the adjoining occupier or owner if that is the circumstances of the particular case.
Having said that, leave aside a situation where somebody says, well, I ought to have been asked for my consent under subsection 11, I wasn't. Had I been, I would have raised these points, and one can see that they may be to do with a private dispute rather than the use of the highway. On the other hand, you may have a case where somebody who isn't a party to the request has genuine highway concerns to raise, perhaps of the kind which could have been raised under Schedule 14 had it been a subsection 1 matter, but there's no procedure by which they can raise those legitimate concerns related to the statutory purpose. But your answer to that, I think the only answer you give, is that Parliament entrusts that to the highway authority.
That's the statute.
As a public body.
That's the statutory scheme, and it's deliberately different. You know, this is in the same section, there are certain highway authority initiated actions that do lead to
where
that
matters
kind of
may have
process.
to go to the minister.
Exactly.
For example, where there is a developer involved in development going on, it's been thought appropriate that there should be an independent adjudication on relevant objections. The other example being subsection 1, the habitual user. But, yeah.
In order to turn it on.
Where there's no request at all, but there is compulsion.
And as I iterate, hopefully not too many times, one is the power here is effectively to drop a curb in the verge. It's something that is being applied for only on highways land, and one can imagine. I think I've made the point.
I've just looked at 5A again. It's always dangerous to start looking at this because the example I was thinking of, say it's a house and the neighbouring property is a big Victorian house that's been turned into a nursery, and they would want to object to a crossway because they'd be saying, look, you've been running 2-year-olds over, because they're always running out. And they might want to say, please don't put a crossway in front of our Victorian nursery house building and so on. But when you look at 5A, it says the need to ensure, so far as practical, safe access to and egress from premises, not the premises, i.e. the one that triggered the notice or the one that's the subject matter of the application. It's premises, which is a pointer you might want to submit, it's a matter for you, that points to the considerations encompassing a situation where the crossover might be relevant to access and egress from premises, not just the adjoining premises.
My Lord, yes. I mean, my primary submission, of course, on that is that subsection 11 is deliberately silent as to any premises. It doesn't use the word premises.
Yeah.
It's leaving such matters to the discretion of the authority. But of course,
But you would say it's reinforced by the fact
reinforced.
that they've got to have safe access, or consider safe access and egress to, access and egress to what? Premises, not the adjoining premises.
Premises is broadly defined as well in section 329,
Yeah.
and as in schedule 14E, anticipating that there would be more than one land interest in premises.
Yeah.
And so for all of those reasons, I mean, my primary submission is that the ordinary words should be given their ordinary meaning, and I've only gone beyond that, in effect, to respond to my learned friend's submission that it's necessary to read in. In fact, my submission is you don't need to read in at all. There's no absurdity, and as a result, the statute enables a non-owner or a non-occupier to make that application, and it enables an application to be made to provide a crossover to more than one set of premises. And it's only if my learned friend is right on both of those points that there would in any event have been an issue in this case, because of course the application was made by the neighbouring owner. And so that by itself wouldn't give rise to any issue. It's only because it serves more than one premises. Or
So even if Mr. Hoare is right that one has a limited or restricted interpretation of any person may apply, that's not enough to get him home because the person who did apply was the owner of the premises.
and paid.
And paid for it.
I think it's got to, he would succeed primarily if he can show that a vehicle crossing presupposes that it's a crossing from the highway to the premises owned by the person making the request.
And that must be an individual set of premises.
Yep, and that's implicit in 11, and it follows from an implicit implication in 1841. I think it's got to be that. The whole section is based in presupposing a link between one set of premises and the highway, and if it strays beyond the confines of that geographically, even though it's in the highway, not in the premises, then it's out with the section.
Well,
I think it's inevitable.
there's got to be a link between crossing from the highway and the premises of the applicant, but it's got to be confined to the premises
Yes.
of the applicant.
Exactly.
It is no good, so that even if it was a lane that served 5 different houses, that wouldn't be good enough.
No.
Mehdi, I hope you have my submissions
Yes,
in response to
yes,
that
the veto
orally
point, yes,
and
yes.
in writing. I've taken my point slightly out of order, but I wanted to focus on the particular points raised today. But those were the submissions I wanted to make in relation to the question of statutory interpretation.
Yes, thank you.
May I turn briefly to the ground 3 and 4?
Yes.
The way I have put our response, and if I may just say the court has the context in light of the questions asked earlier. In the judgment below, it's at tab 7, and it's paragraph 40, first of all, on page 56. The judge there records my submission, as it was, that it's too late to challenge the legality of construction because it was laid down, as the court will read, and it's therefore time barred for judicial review purposes. And the judge then says there's some force in this, but I've been reflecting upon the unlawfulness question. That's because both parties debated a very substantial part of the submission. I judge it needs an answer. The challenge on issue 2 is entirely derivative of it. And then the judge posed himself those 2 questions. In answering the first one at paragraph 43, again, the judge records.
Before we get to 43, one wonders on what basis the judge was deciding to deal with issues that were not the subject of the grant of permission.
The particular
Well,
ground.
Was that it was taken regard to something that was unlawful.
yes.
Exactly. That's at the top of page 111.
So that presupposes that it was unlawful in the first place, because if it was lawful, then there's no need to. There's nothing to challenge.
So on the papers, the deputy judge didn't refuse permission for everything. Oral renewal, top of page 111, any sort of suspicion of a challenge to 2015, along with a number of other grounds, were not granted permission. And the particular ground, my Lord noted earlier, which had come from the oral renewal argument, was that the decision of the chief executive not to remove the crossover was unlawful because he hadn't taken into regard, or sufficient regard, a relevant consideration, namely that the crossover had been unlawfully constructed in the first place. And that's why...
Well, how do you take into account that when according to classic public law principles, it's lawful?
Well, that, if I may just take you back to page 58, the summary of my submission...
I'm trying to imagine the chief executive doing that.
Well, my Lord, we can go to this in a little bit more detail, but the nature of the complaint obviously wasn't a legal submission.
No, I understand.
The core of the complaint was that there had been no consent.
Yes.
And that the council, which it accepts, says it would have been good practice to consult with neighbours. But the way that the issue became formulated below became very much a legal issue of statutory construction.
Yes, it sort of morphed from the way that it's put in the original complaint, as far as I can tell, is that there was a policy of consultation, and it was not in the decision was not taken in conformity with a policy that somebody should be consulted.
Exactly. And then it grew over time, so that in light of the way that that permitted ground
Yes.
was framed, the submissions I made, which are in more, we do have my skeleton argument.
But in 43, you say exactly what we'd be saying. I had read it, but I forgot about it. You said that it was not unlawful because it had never been adjudicated to be unlawful. There's no finding before him or anyone that it's unlawful. No permission has been sought for an extension of time. So therefore, he shouldn't have been dealing with this. So I read 43, and then he gets to 44, and he's still going to deal with it, isn't he, the judge?
He feels it's necessary to deal with as a preliminary issue, in effect. But he does then go on to deal with the consequences for the decision of the chief executive. And he does that, if I can just draw attention to paragraph 78. At the beginning of, so issue 2 was the evaluative exercise, the actual decision that was taken by the chief executive, page 70 of the bundle, paragraph 78. He says, I accept the submission on behalf of the defendant, but at the time of the decision, there was no finding that the crossover was unlawfully constructed. And, my lady, my lord, that is an acceptance of the submission that you've just seen summarised.
Yeah.
But I made that submission, if I may just ask you for to turn to tab 11 of the authorities bundle.
Yes.
At page 98, I recognise at paragraph 12 that the ground of permitted judicial review referred to unlawfulness.
Yes.
And then in terms
Page-
of, this is 98, my lord.
It's not the authorities.
It's
bundle,
the
it's
court-
I'm so sorry.
Yes.
I'm so sorry. Wrong bundle. So forgive me, my lord. At the top of page 98, first of all, paragraph 12, I refer to the permitted ground of appeal and the order of Honour Judge Robinson. And then at 14, I draw attention at that time that the ground of challenge was not that. The original decision in 2015 was unlawful because that claims impermissible on grounds of delay and no extension of time, etc., etc. And no such legal challenge to the construction of the crossover had been made or is now permitted. And I support then those submissions on page 107 at paragraph 48 by reference to the two authorities the court was taken to earlier, Smith and Eastello
Yeah.
and Noble. And so the way that I put the case there and in my skeleton to this court is that notwithstanding the scope of the permitted ground of judicial review, which I accept I have to deal with, when it comes to the evaluative exercise, grounds 3 and 4, is there an error of law in the chief executive's balancing exercise? He, the chief executive, had to proceed on the basis that the crossover was lawful. And in addition to the fact that that point hadn't specifically been made, that's what the chief executive does when one reads his letter, and it's clear
There's
that
no point in granting permission in the High Court on the ground that was accepted.
No.
Indeed, one of the reasons why the public law principle, as stated in Smith and the other authorities, Hoffman and so on, is as it is that so the public in general, including the owner of number 63 of the adjoining property, can rely upon the fact that that decision in 2015 was lawful, unless and until properly challenged and set aside.
my lord, yes, but and yes, and
With all due respect, I simply don't understand the decision to grant permission on the ground identified in the order. It may be my fault.
well, my lord, as is clear from the history, we objected to and sought a contrary order.
And you
But-
maintained your position, effectively.
and maintained our position. But the way in which, as
And
I
the judge
say,
appeared to have agreed with it, saying that we've got quite a lot of chunks of in judgment, all about something which wasn't at issue there. So
Well,
it's all-
he's taken a pragmatic approach,
I
hasn't
suppose,
he,
yeah.
on the basis that the point's an important one and it's been argued out. And I did indicate when Mr. Hall was on his feet that this court is going to have to take a similarly pragmatic view. We may say something about the advisability and the procedure by which it's come before us, but I think it would be grossly unfair to Mrs. Anwar if we weren't to grasp the nettle, given that her counsel has argued the point.
that's partly why I'm giving the explanation I have,
Yes.
because we did not serve a respondent's notice. And I'm happy to, that the reason for that is that the judge recognised
Yes.
that there couldn't be a direct challenge
Yes.
to the 2015 decision, and by reference to Smith and Eastello, I say that when
right.
it comes to the grounds 3 and 4, the point goes nowhere really, because
Yes.
the chief executive had to proceed on the basis it was lawful. What he had to do was to deal with the complaint. So, you didn't get my consent. And he said, well, our practice at the time suggests we should have done. And that's something that is taken into account. But the real force of his balancing exercise is that the neighbours have had the use of it for several years. They park on it. It's convenient for them. It's very difficult to move because of the street tree and the light, as the court has seen. It's very unfortunate, and the chief executive recognises the unpleasantness of stress and inconvenience. A bollard can be provided that would prevent driving from the crossover, which is obviously at the carriageway, edge of the footway, onto your particular property.
all of this is bizarre, you see, because if it's a shared driveway, they've got rights to go over it, which seems to be in the assumption they can't put a bollard there because they'll be interfering with the right that the left-hand property has to go over it. It's bizarre to have a case where we have no facts.
Well, my lord, there's-
Just on this concept of shared driveway, I mean, I did look at the title, and it's not as I couldn't see any in either the freehold titles or leasehold title any shared rights, as it were, in relation to the driveway. It seems to have happened as a matter of practice, maybe
Lord,
maybe prescriptive.
and my lord, I don't want to set hairs running, but the powers we're concerned about are in the highways.
Of course,
Yes,
yeah.
No, I
What
understand.
one does in
Understand.
one's own front garden, in terms of whether you've got a wall there or not, if you wanted to create an off-street parking space, then subject to reliance on the appropriate permitted development rights or planning permission, that is something you can achieve on your own land ownership. And so where the crossover is facilitating an access, it's 3.6 metres because it's wider than a single access because of angles of approach, as I understand it. But it's not the case that the crossover must always line up precisely with what structures are on the front garden or the off-street parking space of someone's property.
Where did you get the 3.6 metre dimensions from?
The crossover that was put in place is...
I saw the 2.7 on
That's
the
the
photo.
distance, what appears to be the distance measured in the judgment between the wall.
Yes.
And my understanding is that that's not an up-to-date photo, but I
Right.
don't want to go too far down to that route because it's not an evidential matter. But the 3.6 metre distance is given in page 155 of the core bundle, where it says that the reduced cost of a standard 3.6 metre wide
Standard, yes.
shared ownership. And there is later, forgive me, in the policies that are being referred to, again, I'm not sure to what extent the court wants me to go down this route, but on page 17A, at point 6, this is in a March 2006 council policy document on the left-hand side at 6. There are references to the normal width of a vehicle access being 2.4 metres and it shouldn't exceed 3.5 metres.
Can I go back to page 44 of the photograph? I've now had another thought. I mean, it's my fault for being so obsessed by facts, I suppose. But what exactly is the thing that we're talking about? Is it the bits of the curb that are taken away? Is that the crossover? Or is that the works? And the crossover is because those works have been executed, you can thereafter cross over the next bit, which is the footway, and then you'll arrive at private property. So the 2.7 there is the between the walls, but is the thing that's the works that have been carried out a much wider thing? Because that may be relevant, because we're assuming the crossway is the entrance, and it may not be. It may be the amount of the pavement that you take away, the amount of the curbstones.
My understanding is it will be both. It'll so again the same letter, the 10th of December 2015 letter explains.
So just where was that again? I'm close to it.
Page 155. The starting point of this situation is that the council was proposing to undertake a infrastructure renewal programme. So it was looking to resurface and maintain the curbs and the pavements effectively. And as part of, because they were doing the works anyway, they offered to residents the opportunity to have, rather than raised curbs put back, the curbs, as you can see on the photograph, that are level with the carriageway.
But what is interesting about it then, Mr. Williams, sorry to interrupt you, is that the council had in mind a shared vehicle crossover, because if one compares this with the policy document that you so helpfully showed us at 178, the normal width would be 2.4 metres and it shouldn't exceed 3.5. Well, they've said 3.6, but I mean, that's just a small amount. But it seems quite clear that as part of this special offer bargain basement price that they're offering, the council have already got in mind the possibility that it's, or rather the likelihood, they're not offering a single crossover, they're offering a double one.
Melody, yes. I mean, that,
or rather a 1.5.
They're certainly offering a width that would be appropriate.
Accommodate both.
I think what they're actually offering, when you analyse it in ego terms, is to carry out works, the purpose of which will enable vehicles to cross a pavement at a width that would enable them to access one or two private properties. That's what they're actually doing. And it's we who are introducing the words shared or joint or individual. It is works for the purpose of constructing a crossway. And then you get to the private properties. You take away the pavement and the curbstones. You might have to do something to reinforce the pavement. And then you arrive at the garden. And thereafter, that's where your remit ends.
My lord, and yes, and in that same letter on page 155, if one reads on, past the bit where you have to send your cheque, obviously, that you might have to do works within your own garden. Now,
then it goes on in the next paragraph. If works to the front of the property are not carried out, etc., we will unfortunately have to remove the vehicle crossover and reinstate the footway. So the supposition upon which this letter seems to be carried out is that in the street there would have been a number of existing crossovers. This is just a maintenance exercise to resurface, to make sure everything's up to standard. But they're dealing with existing crossovers. That turned out to be a mistake, as the council later admitted. And then it's dealt with as a request under subsection 11. So this letter comes with a little bit of a health warning.
But also, apart from anything else, they wouldn't have had the power to do it if there was already a crossover, because we've already seen what 184 doesn't apply.
And they say at the end, if you've got any queries regarding the reduced vehicle rate crossover for your own property. So they are contemplating a smaller set of works to facilitate a construction, a crossing, which would only enable access to one property.
And this happens to be a letter written to the owner of one property
Yeah,
only.
not the other.
We don't know of any other letter, but still. So there's a limit to how far we can...
As the court will have read through the complaints, there has been admissions by the council of this could have been done better, if I may put it that way, but also references to the difficulty in actually unpicking after the period of time some of the correspondence and details. But the position arrived at through the investigation of the chief executive is that, in effect, through conversations and the submission of checks, there was an application made by the neighbouring property, and that was the cause of the works. It's difficult, I appreciate the court's questions, it's difficult for me to say precisely what happened in 2015 or whether the letter's entirely in accordance with what happened. But my understanding from the chief executive's letter, which I take as my primary factual basis, given that that's what's being challenged, is that there was an understanding through the complaint process that requests had been made, consent hadn't been obtained, payment had been made, and the works had been executed by the Highway Authority. And so in my submission, once one starts grounds 3 and 4 from the appropriate starting point, which is that the crossing is to be treated as lawful, then it really is just a merits challenge, and the respective weight to be given to the convenience of one set of occupiers and the other was a matter for the chief executive.
Can I just ask a question on Smith and East Ello?
Yeah.
That was a challenge to a decision, I think, on a compulsory purchase order. So it wasn't judicial review, it was statutory review. And it was subject to the 6 weeks absolute time limit for bringing a challenge. So it was subject and accompanied by an ouster clause preventing any other challenges. So we should perhaps just bear that in mind about Smith. We were also taken to Noble, which was judicial review of a decision by a local planning authority, not statutory review. The same fundamental principle applies, namely that decisions are lawful unless and until set aside by a court in proceedings to challenge them. But I think we were being taken to a passage which says, well, this is under the control of the court. What that's getting at, as I understand it, is someone can make an application to extend time. For which you can't do in the Smith and East Ello situation. I think it's just a note of caution there about how the authority is to be applied. But here there was no application to extend time in relation to the 2015.
Well, there was no application to
decision.
challenge the
No,
2015 decision, let alone an application
absolutely.
to extend time.
But so
I recognise the distinction
just got to be
between
a
an
little
absolute...
bit careful about applying the authorities.
But in my submission, I hope the way I put it is that the appropriate starting point or the appropriate approach for the chief executive was to treat the decision as lawful at the time that he was making
Roche and so on.
his decision. So, my lord, unless I can assist you further, those are my submissions.
Are you saying nothing about Article 1 of the first protocol?
My lord, I can do. My submission in relation to Article 1 of the first protocol, forgive me, as in my skeleton argument, is that there's no infringement of Article 1 from the construction of a crossover in only highways land. As my Lord Justice Lewis indicated earlier, reliance on the field court authority is of no assistance, because that was a case of direct trespass, and the particular issue relating to whether or not the council, having laid the tarmac on the access road, was encouraging or permitting a trespass was relevant to the assessment of damages, having found that there was a trespass. If in this case the use of the crossover, which is not itself a trespass on anyone's land, gives rise to any private law issue, by way of, for example, trespass, then the crossover does nothing to take away the full property rights that the adjoining landowner.
Well, that's the short answer, isn't it?
Yeah.
That you can still sue for trespass if there is a trespass.
Exactly.
Well, it doesn't self-trespass, it doesn't permit anybody else or cause anybody else to trespass. That all depends on whether or not they're going to stop them, or whether the homeowner will stop them.
And the example of that would be the chief executive was proposing a bollard, but there's no reason why you can't take measures on your own land ownership to
You can
prevent
put
some.
her own bollard up.
And if there is trespass, but I use the example of the bollard because it demonstrates that this has done nothing to alter the extent to which the appellant is able to exercise her full property rights. The cases that are given by reference to the European Court of Justice are very different on their facts, obviously, but they all, or they both, involve fundamentally a de facto or actual expropriation of property.
But one was flooding, which meant the access couldn't be gained and they had to go 20 miles, but there was actual evidence there that at least 40% of the value of the land had been lost because you had to go 20 miles around the neighbouring village. The second case relied on was actual seizure of property pending the outcome of criminal proceedings.
Yeah.
And as my lord indicated earlier, there had already been an assessment that the effect of the access road being underwater significantly devalued the property.
Yeah.
And the real issue was that the authority in that case was refusing to pay out compensation, notwithstanding that being 10 years or 15 years, I forget.
But if you're going to use Article 1, Protocol 1 as an interpretation tool, which I think is the way that Mr. Hall's putting it, because he's not saying, well, there is in fact an infringement of his client's property right, is to say that the alternative interpretation contended for will, by your side, would necessarily involve encroachment on people's property rights, and therefore we must take that into account in looking at which of the two viable interpretations we prefer. And if the position is it won't and couldn't because it only affects the highway, then the argument doesn't get off the ground.
No, there's no necessary infringement of any convention right as a result of the judge's interpretation.
But he has to go that far, doesn't he? Say that it's an across-the-board thing. It doesn't matter that it might, in a particular example, do that, because we're talking about interpretation.
In terms of Section 3,
Yes.
and the way that Section 3,
Yes.
that's absolutely right as a point of statutory interpretation. And there isn't here, as my own friend made clear, an assertion that on the facts of this case there was some disproportionate interference. That's not this case. Hard to see how it could be, but as a point of statutory interpretation, I agree there's no necessary operation of the statute.
But aren't we looking at the wrong way around? The starting point is to look at what Parliament intended in the 1980 Highways Act. And if it means what you say, that's what the Act says. Then we go on to Section 3, and if that interpretation were to give rise to a breach of a convention right, and it could be the claimant's or it could be somebody else's, but there has to be the establishment of a breach of a convention right. And firstly, it doesn't extend into private property. Secondly, it doesn't take away the rights to control interference with private property. And thirdly, we've got absolutely no evidence at all that anyone's property would be worth less rather than more or just the same with the curb taken down. We just don't have any basis, do we?
And as I said, I agree entirely with that. And on my interpretation, this is essentially a facilitative power to provide access. It doesn't have to be taken up on one's own property.
Yes, that's a further point. You say it's a purely facilitative power, which does not have to be exercised. Yes.
unless I can deal with any other points from the court.
No.
Thank you.
Clive, any
No,
other-
no, thanks.
Thank you very much, Mr. Williams. Yes, Mr.
Lady, thank you. Just one or slightly more than one handful of points, and largely in respect to questions of your ladyship and your lordships. There was or seemed to be a suggestion that it was my case that if an owner makes an application under subsection 11, everyone must make separate applications, but you can only grant it if it serves that property. Well, my point to that is a simple one, that anyone in the block of flats example, or in the Mews example, your ladyship's, my Lord, Lord Justice Holgate's example, would benefit. They benefit equally. Now, it may be that there isn't the right in the top of a block of flats to have a car, or it may be that there's some sort of a contractual arrangement preventing it elsewhere. But any of them potentially would have that right, and therefore it doesn't go against the statutory purpose to require them all to make the application. And just a procedural point, the way that the council addressed this particular scheme in 2015 is actually illustrative of how this can be done very informally. Because in that case, the council presupposed that everyone, so in fact, there's not been any judicial or other discussion about this, and we all agree that there was in effect an application under subsection 11, but you will have noticed in that letter to the adjoining property, there was no mention of the statute at all. It was simply, you can ask for this discounted application. So were it the case that one person applied, the council could easily write to all of them and say, there's an application by flat 13 in number 3 in the Mews, and you all have to consent to this. They could do that. Alternatively, this could alert them to the fact that one of the cars was using the curb, and therefore subsection 1 could apply, and they could use that subsection 2. So my submission, that doesn't damage my case. It's not an absurd case that one person only can benefit. Inevitably, they would all benefit. And then a question I took down of my Lord Justice Holgate. Appellant has said consent is required, but really subsection 11 objection procedure isn't brought in, and someone who said he isn't joining and has a veto. But the corollary is that if the Highways Agency thinks it's a good idea, it can act under subsection 1, but outcome is all owners and occupiers are liable to pay. Well, my only response to that would be a perfectly fair response, but the secondary point is that if the Highways Agency did act under subsection 1, anyone can object to being required to pay. So flat number 3 in property number 2 in the back of a Mews, for example, could say, I'm not entitled to have a car, I don't have a car, it's not fair for me to pay to the costs, and the council would have to have that regard to that.
So end up not paying.
And end up not paying because they said it wouldn't be fair to
But going back to subsection 11,
yes,
the scheme couldn't go ahead because not everyone consented.
Yes, but this is in response to your lordship's question that if the council then went back and used subsection 1, there wouldn't be a need for a consent. So there are ways around this that are perfectly compatible with the statutory purpose, that address the circumstances of a very large number of people, one of whom is a belligerent neighbour who just objects to everything. There are ways around that.
Hold on. Can I get this straight first of all?
Yes.
We're not in section 1 or subsection 3 territory for the moment. Assuming we've got a Victorian house with 3 flats, first, second and third floor, ground first and second floor, and number the bottom right in and say, can we have it under subsection 11, or they don't refer to the statute? And you said the council can write to the other 2 flats and say there's been this application. What happens if they both write in and say, no, we don't want it?
Then they can't do it on subsection 11. That must
They can't. Right. So
under subsection 11.
Everyone has got to consent.
Because
It is
that's
a right of veto, basically.
It is about it, right?
There's no statutory scheme that could be otherwise. But there are provisions whereby the council can address that mischief, if that is how it's put. So, yes, in a way, that is a countervailing mischief to my point, which is an adjoining property on my case has no right. In fact, this is agreed. Would not have to be consulted and could end up in Mrs. Anwar's situation where she's got a drop curb she doesn't want, and she can't deal with it under the statute.
But if they all have to consent and they don't, and they're all very good citizens, and they've all got very nice cars which they don't take over the very high curb because it'll damage their exhaust pipes, so you can't rely on 1851, and the planning permission was donkeys years ago. There's nothing you can do.
No, but
you've got to get everybody to agree.
But yes, it's if you like, my lord, I accept that that's a countervailing mischief, and there are two mischiefs. I submit it's worse for the law to be that you can apply. The council says we'll have to do it on your neighbour, and there's no requirement to consult them, and no ability of that neighbour to make the objections that would be able to be made if the council made the application rather than.
Well, that presupposes they've got the right to object if the council made the application.
Well,
we're back into that territory.
Back into that territory. Yes, we can go back there. I think I've addressed your lordships and your ladyship.
Well, I think we know what your points are on that. I hope fairly.
The nursery point, premises and a premises. Well, I submit to that's my Lord Justice Lewis.
It's not the absence of a; it's the absence of the.
Absence of a or the, but it is right to say though that the different that uses premises in a very different way to the other subsections. So, and I agree with my lord. I agree with my lord that is correct. That must mean any premises. But if one looks at subsection 1. It talks about the occupier of any premises. Clearly, I submit, meaning any individual premises. And then subsection 3, two premises adjoining must mean premises adjoining. To construct, so subsection 3A, to construct a crossing over a curbed footway so as to provide access for to or from the carriageway of the highway from or to premises adjoining, that is specific premises. But subsection 5, subsection 5A, yes, it says safe access or egress from premises. I agree, it doesn't say the premises, a premises. That does seem to have a wider application. So I accept that the words must take their colour. Well, it's my proposition. Words must take their colour from the appropriate other sections and also from a logical reading of the sections. So I agree that it would be perfectly appropriate for a nursery to make that objection and for the council to take into account that objection. The council's right is unlimited. For what it's worth, I probably should go, that reminds me that I probably should make clear that I concede the point about Schedule 14 being exclusive, not inclusive, because having listened to the very useful discussion between my learned friend and your lordships, I do fully accept that there is a distinction between a specific grounds on which an application can be made, especially given that the grounds have to be set out on the one hand, and on the other hand, the council having a public law power having to have regard to some circumstances and not others. But I've already made submissions quite fully about how wide those objections are that I needn't repeat. Your lordships and your ladyship will be well familiar with them. Finally, I concede an important point about time and the challenge. I go back to my submission after the luncheon adjournment that this is a situation where, faced with the knowledge of this curb dropping, Mrs. Anwar could do nothing but ask for the curb to be raised. I accept, of course, the criticism that will be made about the timing that she did that, but what else could she do but ask the council to do it? And what other response would she expect from the administrative court if she didn't, other than ask for the curb to be reduced? On that basis, the suggestion that the council has to consider the initial decision as lawful and has the Noble and Smith, with the Noble and Smith exception in mind, is in my submission a misanalysis, because this is the first time the council has had the opportunity to consider a complaint that they acted unlawfully. Now, accepting, of course, that Mrs. Anwar did not use the services of a lawyer, why should she think
She didn't say that it was unlawful.
But that's my point. She didn't know about the law, and she didn't use the legal avenues to challenge
That
it.
may be so, but I mean, she did say it was contrary to their policy.
She said contrary to their policy, and I was not consulted. And if there was a legal requirement not to consult her, but to consult her if it was Section 5 or to require her to make the application, then, and in addition, looking at the very informal way in which the council addressed these applications, it could easily have sent a letter to all properties adjoining the premises and say, if you have a property that goes and wants a curb that has to go to the next door property, then of course we'd expect an application from both, or not just a check, but consent. And that's not consent technically, that would be the application being made by both premises.
I thought you referred to the public sector equality duty as well, which is a matter of law. But leaving that to one side, what she could have done is this. She could have complained quickly to the council and said, you mustn't do this. And then if she'd applied later in 2019 to the Judicial Review Court, they would have said, no, you're out of time. If she hasn't, as she hasn't, applied until 2021 or complained until 2021, the judge could have refused permission on two separate grounds. One, you are out of time. Two, in any event, you should have taken this up at some stage with the council. So, although I see the force for saying you can extend time when people are acting reasonably, I'm not sure that it gets you entirely home, because it may not be reasonable to wait 5 years to make a complaint.
I don't have any evidence.
You don't have any answer to that, yeah, or evidence on that, yeah. But that's the problem. It's not
I
she complained
yeah.
and then she came to court. She waited 5 years, then she complained, and then she came.
I do understand it.
But sorry. Don't read that.
I think, Mrs. Anwar, that you have to leave it to your barrister to address the court. But if you want to instruct him,
Yes,
maybe we'll rise for a minute so that you can take some time.
Check it, see. It kept going backwards and forwards.
Yeah, no, I understand.
First they said that they hadn't done it. They said, you need to visit planning.
Right.
Yeah. Sorry, page 181.
Doesn't date.
Yes. No, that's when the process started. Before that, this lawyer said that it hadn't been nothing to do with it.
That's the excuse and go everywhere.
I'm ready for their lordships and their ladyship.
Court rise agreeable.
Yes, Mr.
My lord, so my lady, my lords, I am grateful for that time. There is an extensive history of unhappiness between these two neighbours.
Yes,
and there
we
is,
gathered.
I am told, a history of oral complaints to the council before the complaint by email, as I'm sure that your ladyship and your lordships can imagine, but I can't point to anything concrete.
Right. Okay. So this is the first written complaint.
Indeed. There is also reference to a complaint from the neighbour, from the landlord, actually, the freeholder.
Yes, I've seen that. Mr. Khan
Indeed.
or Khan.
Khan, I think, May 20.
Yes, I remember reading Mr. Khan's letter some time ago. So
Yep.
okay.
Those are all my suggestions.
Well, thank you very much. Thank you not only to council but to those sitting behind them, and we will want to take some time to consider your submissions, of course. So you won't get an answer today, Mrs. Anwar, I'm afraid. We will consider very carefully everything that both councils have said to us, and we will produce our judgment in a draft form, which will be circulated to council. It can be, of course, shared with clients, but on the strict understanding that it is not for dissemination or discussion with anybody else until after the judgment is handed down formally. There will be the opportunity in the usual way to offer factual corrections that are obvious or any typing errors. It's not an opportunity to re-argue the case. I know you both know that. And of course, both of you will be well aware of the obligations, but I have to keep reminding people of this, that anything which is disseminated in draft form is strictly confidential. Any breach of the duty of confidentiality can have very serious consequences because it can be treated as a contempt of court. That's not waving a big stick, it just happens to be what we have to remind people about. I can't guarantee how quickly we can get this out to you, but we'll obviously try and do it as fast as we can. I'm very well aware that it is a matter of considerable concern to Mrs. Anwar, and that she doesn't want this hanging over her head for any longer than has to be necessary. So thank you all very much indeed.
Court rise agreeable.